Hi, can everybody hear me? Great. I'm really excited to be here. My name is Bahane Hobel. I run the alcohol beverage law practice at Dickinson, Peatman, and Fogarty out of Napa. We also have an office here in Santa Rosa. Our firm does primarily wine law. I focus on the regulatory and licensing aspects, but we do everything from litigation to intellectual property to general business work. Today what we're going to do is go through some of the hot topics in alcohol beverage law and regulation for 2020. And at the end I actually touch on a couple of topics that aren't really my specialty or related to alcohol beverage law particularly, but are hot topics absolutely for wine industry businesses, and something you should, a couple of things you should just be aware of and know they're coming down the pike in 2020 or 2021 even. Because we're going through a bunch of different topics, please feel free to raise your hand for questions as we go, because I will, as you can see, be going through quite a number of different topics. Because there are so many, I'll probably go through them a little fast, but you can definitely stop me for questions if you have them. So the first thing I'm going to do is really just a quick background on the legal landscape of wine historically and why we are where we are in this industry. Alcohol beverages are one of two products mentioned in the Constitution, alcohol and guns. So this is very important to our country, and that is really why we are in such a highly regulated and really difficult to operate in industry when compared to other consumer goods. The basis of our current regulatory system is really prohibition, which was in the 1930s. So it's amazing to think that something that happened so long ago really governs the way we operate now when the world was a completely different place. But it is what it is. Pre-prohibition, the United States saw a huge rise in drunkenness, alcohol consumption. I think the average American drank nearly 7 gallons of alcohol a year, and it's over 3 times what the average American drinks today. This was really promoted by what was called the saloon culture, where the bars and local pubs were owned by the suppliers, so there was just this oversupply and overconsumption problem. This was combined with a couple other social justice movements at the time to basically support passage of the 18th Amendment, which was prohibition. The 18th Amendment did not prohibit the consumption of alcohol, but it prohibited the sale of alcohol, essentially, in the most basic terms. It did allow for home brewing, which we still have on our books today. It allowed for medicinal wine, sacramental wine, a couple other things, and people got very creative. You saw people getting prescriptions for port for their headaches. And you saw in Napa and Sonoma a lot of people convert to making a lot more sacramental wine just to keep their businesses going, and using their facilities for other purposes. As prohibition progressed, everybody realized this wasn't working quite the way they thought it would. There was actually an increase in crime. We saw a lot of bootlegging. It was kind of the days of Al Capone and moonshine. And it also happened to coincide with the decline in the U.S. economy as we neared the Great Depression. And so we were losing a lot of tax revenue from, this prohibition on the sale of alcohol. Because of all these reasons, prohibition was repealed with the 21st Amendment in 1933. And the language of the 21st Amendment really is why our systems are the way we are today. The 21st Amendment basically gave each state the right to regulate alcohol coming into its state and within its borders. That, coupled with the Federal Commerce Clause, which governs the traverse of goods between the states, creates this really tough conflict where you have federal trying to regulate something that's already regulated by the states. That's why we have so many issues with things like direct-to-consumer shipping. That's why we have to get licensed in 45 states for anything we want to do, to ship wine. But it's again, these things come out of systems that were in place, almost 100 years ago now. federal and state really had common objectives when enacting all their new legislation, and we still see them all in place today. And we're really going to see this in the first topic we're going to discuss, which is the federal trade practice enforcement actions that are happening right now with TTB. Really the common goals, which everyone I think is familiar with, is to promote temperance and avoid overconsumption, to promote or to prevent vertical integration. That's why we have our tied house laws and the 3-tier system, to prevent cross-ownership, but also prevent bribery by giving things of value and free goods between the tiers, and also to generate tax revenue. Those are really the 3 big goals that we see now in our current federal and state regulatory structures. So this leads us into our first hot topic, which is TTB's current trade enforcement actions. Is everybody or anybody here familiar with TTB's actions in the past year or so? No. Okay, so I'll tell you what's been happening. TTB has targeted a lot of mostly small wineries for engaging in consignment sale violations. And there have been probably at this point about 25 suspensions of small wineries and wholesalers for consignment sale violations. And they're all one-day suspensions at this point, and we'll talk a little bit about what those cases were about, how we dealt with them, and how they were eventually resolved. But before we get there, let's go through the other TTB trade practice issues. There's basically 4, which I've listed here: exclusive outlet, commercial bribery, tied house, and consignment sales. All of them are essentially getting to the same issue, which is suppliers should not bribe a retailer to carry their product or otherwise, exert undue influence over them in a way that would result in their product being carried to the exclusion of somebody else. So exclusive outlet is the first one. What this says in the most basic terms is that you cannot, as a supplier, require a retailer to exclusively carry your products to the exclusion of someone else's products. Exclusion is required in 3 of the trade practices under federal law. It is not required under consignment sales, and we're going to talk about that because that's a huge factor in why TTB has pursued consignment sales. We've seen action on all of these trade practices, even though there might not have been a showing of exclusion. TTB has found exclusives and gotten huge settlements out of industry members for various trade practices. The second one is commercial bribery. We see this a lot. You are not, as a supplier, supposed to essentially bribe a wholesaler or a retailer to have them carry your product to the exclusion of another product. We see this a lot with wholesaler incentive programs. These obviously exist. So how are they legal? Under federal law, they're legal as long as you are not giving something that can only be used by one person. So if you're giving your wholesaler a trip to Hawaii to give to one of its employees, that's a problem. That's not valid under federal law. If you're giving them $10,000 to do what they want with it, that's okay. You are not allowed to give any sort of incentives like this to retailers. That's completely prohibited. State law, California ABC hadn't really dealt with it. They knew it was happening. They threw it in a contest provision that had nothing to do with incentive programs, but their view is essentially as long as you're complying with state law or with federal law, we're okay with it. Tied house. So tied house should be the one everyone is really the most familiar with. The most simple way to think of tied house is that you as a supplier should not be giving free goods or anything of value to a retailer. This includes giving them money. This includes holding an ownership interest in them. This includes holding an ownership interest in a property that they are leasing. These are all prohibited tied house violations. There are a lot of exceptions to these, of course, in California especially. And again, this requires a showing of exclusion. So the 3 we just talked about, tied house, commercial bribery, and exclusive outlet, all require exclusion. What does that mean? That means the activity that you are doing to bribe the retailer results in them not carrying any products of your competitors. The way this has been analyzed and interpreted over the years basically makes it impossible for TTB to prove exclusion. They basically have to show that no other products are carried, and that just doesn't happen. There's always enough. So because they have such a high burden of proof on these other three, they very rarely go after them. They have gone after them, of course, and we've seen big settlements where it was very clearly an act of exclusive outlet, or it's usually more like slotting fees and things like that we see them take action on. But that is why, here's a slotting fee example. They got a $1.9 million settlement out of several suppliers who were paying slotting fees to casinos in Nevada. This happened in 2012. 2011, I'm sorry. Another one where we saw very recently was the shelf schematics issue that came up. There's a provision that is an exception to the tied house rules that says a supplier can provide a retailer's shelf schematics, which means you can give them a diagram that says this is where I think my products should be in your store. You can't go in there and tell them what other products to buy. You can't go in there and really mess. We definitely can't touch other people's products. You can rearrange your own. Suppliers and wholesalers especially, and still do, really took advantage of this provision to basically start staffing retailers with their own staff and having the suppliers' employees essentially running the schematics and running the inventory at the retailers. For many years, all of us alcohol beverage lawyers were told, this happens all the time, it's fine, we all do it. And we all said, you're crazy, there's no way this is permissible. So finally, one of my colleagues at another firm, their clients just got sick of it because it was just anti-competitive, which is really what this is meant to prevent. They took it to TTB, and TTB said, absolutely, you cannot be doing this. People are still doing it, they're just kind of taking the risk because, again, you have to prove exclusion, and there are all these other products there, but it is technically a prohibited practice. So the focus has now been in the past year, now 2 years, by TTB on consignment sales. Consignment sales, how we all think of them is, I'm gonna sell you something, and if you don't sell it, you can return it to me. TTB has a much broader definition of that, and it includes in its list of things that are included as consignment sales, selling to a retailer or a wholesaler with the understanding and agreement that they don't have to pay you until they've sold the product. So I'm gonna sell my product to Bottle Barn, and I say, listen, I'm a small winery producer, just don't worry about paying me until you've sold it, then you don't have to worry about it. That is illegal under federal law. State law, they don't deal with consignment sales between wholesalers. Consignment sales with retailers are illegal under state law, under any circumstance. So TTB focused on that provision that I just talked about and went after about 22 wineries, all small, working with one particular wholesaler in New York currently. That's been the focus of their current investigations for consignment sales, based on a model that is used actually by a lot of wholesalers throughout the country. But this is a perfect case of everybody's doing it, it must be legal, when any of us in the legal world looking at it, no, it's just not legal really if it's done in this way. If you have an agreement as a wholesaler with your supplier that they don't have to pay you until you sold it, that's illegal. In our cases, so I worked with 12 of the wineries that were involved here, and in our cases, the argument was that there was no actual agreement that they didn't have to sell until they didn't have to get paid until it was sold. They were just giving extended terms. The reason this works is because there's no credit term requirement with wholesalers. So credit terms are on your invoice, 30 days, you pay me after delivery, right? That's required for retailers, but under federal and state law, there's no minimum or maximum required credit terms. So you can give a wholesaler 180 days to pay. You can give a wholesaler 360 days to pay. So there's this disconnect between having these unlimited credit terms permitted and TTB saying, well, they're not paying you until they've been paid, so that's a violation. TTB had to prove two things. One, they have to show an agreement, that there was this agreement not to be paid. And 2, they had to show there was a willful violation of the law. In order for TTB to suspend anybody, rather than just give them a warning, they need to show a willful violation of the law. I have been on 2 panels with TTB on this topic, and they still cannot answer my question as to how there's a willful violation of the law if nobody knew they were doing anything wrong. They all really just merited warnings. They don't have an answer for that. In the end, we all ended up settling because we did go into litigation. 12 of the wineries and the wholesalers banded together. There's 3 law firms working on it. We took it to TTB. TTB does not have its own judges. So all of the cases were spread to the Bureau of Mines and the Environmental Protection Agency and all these magistrate judges who knew nothing about alcohol beverage law. And because of that, they were unable to consolidate the cases, even though they're all from the same agency. And really the cost-benefit analysis didn't make sense for any of our clients who are small wineries at that point, where they were all, we got TTB to offer 1-day suspensions that would have no future impact, wouldn't count as a first strike. And in our at least all the ones we did as part of the litigation, the settlement documents, the clients expressly got to state that they still did not believe they violated the law, which is great. So that's where we ended up. This is not over. TTB is still investigating people, so it's a good time to just look at your practices. Make sure you have credit terms on your invoices. To retailers, they have to be 30 days. To wholesalers, it can be any time period, but it should be on your invoice. And make sure you follow up to get paid. Because if you just wait and you have this implied agreement, they could really come after you. It's, 1-day suspension for most people is not that big of a deal, but it does have other impacts on your licensing. It's on your record. It always has to be disclosed to agencies going forward. So something to know. And TTB got another $5 million for trade enforcement in 2020. And this is really the only area that they can do enforcement. So make sure to stay on top of that. Are there any questions on this? Yes. Kim has a microphone for you.
Well, I think I'm just reiterating maybe what you said, but so if you just have listed extended credit terms, for instance, 90 days, then legally you're okay. 90 days would be a way to get around the consignment regulations if you give a wholesaler extended terms.
Did everyone hear her question? Okay. Yes, if you are giving a wholesaler 90 days to pay, that's fine. I wouldn't say it's a way to get around the kind of provisions. What I would say is it is okay so long as you also do not have an agreement with them that can be tracked down by TTB that says you agree that you will not be paid until they get paid. That's really the crux of the issue. So, but yes, a 90-day term is absolutely acceptable with a wholesaler. Run.
Thank you. Just to clarify that, can you have a policy where you offer to sale within 90 days or even a year policy, but then have an agreement to buy back any unsold product?
No. Buying back unsold product is a consignment sale, so that's basically never allowed. It's allowed if you delivered the wrong products. Very specifically, they ordered something and you delivered something wrong to them. Or if it was damaged or defective in some way, and you get pretty clear notice quickly, but returns are not permitted.
Okay.
Yeah. The only time you can ever, as a supplier, really take a return is if it's damaged or defective, or if it's I just blanked. If you're working with a nonprofit, I'm sorry. That's under federal law. State law doesn't actually care whether or not you return to a wholesaler, but federal law sees that as a consignment sale. It's defined as selling with the privilege of return. So.
You said earlier that exchange of money was not okay, but unless it denied a sale of someone else. Am I understanding that correctly? You can give money to somebody as long as it's not attached to the sale.
No.
No?
Do you mean for the wholesaler incentive programs?
Right.
any money given between different tiers is always viewed in connection with the sale or marketing of alcohol. So you can give a wholesaler $10,000 as an incentive for their, for their company to do well on a brand or to help them market a brand. That's fine. What you can't do is give them something that can be used only for the benefit of one person, like a trip or a watch or a TV or something like that.
So if there's a single owner, you're giving it to the single owner that owns the store. That's kind of
so you're talking about a store. That's a retailer. You definitely can't give anything to retailers. You can't give retailers any gifts.
Okay.
The only gifts you can give retailers are retailer advertising specialties, which have a value no more of $1 to you cost, like T-shirts or coasters or whatever.
But you said something about, maybe you could describe it to me a little better, that if you do something, or you talk to them something that denies a sale from another winery, in other words.
Exclusion.
Exclusion, that was
Yes.
your word. Okay, so that...
Exclusion is required under federal law for any showing of commercial bribery, tied house, or exclusive outlet. It is not required under state law. So state law, if you just give it, you're in violation. So that's why when we're analyzing, that was a discussion of TTB trade practices, so that's a good point to make. State law is much stricter, and so that's why we don't give things to retailers in California or any state, because state laws have what's called a per se rule, meaning just doing the action in and of itself is illegal, regardless of the consequence and regardless of your intent. So even if you give Bottle Barn $1,000, that's illegal, even if you didn't mean to exclude other people, and even if it doesn't result in the exclusion of other people. You just can't do it.
But that's not true federally.
It's not true federally, but you're subject to both laws, and California governs because it's stricter. And every state has that rule.
That one seems to make more sense to me.
Yeah.
Because we all know it goes on out there.
Right.
All the time. And it seems to, just by giving someone an incentive, by definition indirectly, you're denying another sale.
Right. But it's just hard to prove on a federal level, which is why all the analysis is always done at the state level.
Okay, thank you.
Yep. All right. Oh, yes, one more. And then we're going to move on.
Sorry.
So I have a statewide broker
Okay.
that we've been working with for over a decade. And so they sell wines basically that, we provide them samples. They ship wines out of a location that we pay for the storage and so forth. They collect the money though.
Are they licensed?
They are licensed as a distributor or as a broker.
As
Yes.
anything?
Yes,
Okay.
they are. Yes, they are.
Okay.
Yeah, so is there a conflict? I mean, is that a consignment? Is that viewed as a
Well, I don't
consignment?
know. I'm happy to talk to you about it after. I don't know
Yeah.
enough about the structure of your relationship and how
Okay.
the product and money flows to be able to answer that. So.
Okay, right,
Yeah.
we'll talk later.
Brokers are tricky too, because people classify themselves as brokers all the time and do these deals that they really shouldn't be doing. So that's how a lot of these consignment sale cases came up. This wholesaler in New York calls himself a broker, but he's a wholesaler. He's a licensed wholesaler. So he cannot be acting as a broker, which is technically an employee or a contractor of the winery. So it happens in this industry a lot. People just see kind of easier ways to do business, and they do it without really thinking about whether it's legal or not. Okay, so the next hot topic is federal excise tax credits for wine. In 2017, Congress passed the Tax Cuts and Jobs Act, and that essentially put in for 2018 and 2019 only some really good tax credits for wine. It basically gave a full $1 off the $1.07 excise tax credit for wine up to 16%, which is most of what we deal with here. It increased that tax limit, it puts wines up to 16% in that $1.07 range instead of $1.57. And it also gave sparkling wines and imported wines some good credits as well. That is set to expire in about 3 weeks, and nothing has been done about it yet. Obviously, there's been a lot of activity. well, before I talk about current status, I'll just kind of go over quickly what the rules are, because my guess is they will stay in place. Nothing's happened yet, but my guess is they'll stay in place. So if they stay in place, this is what it's going to look like. It's going to be the same things you've been dealing with for the past 2 years. You get the dollar per wine gallon on your first 30,000 gallons, and then it's tiered down from there. This is different than the small producer tax credit that we had for many years, because this is available to wineries of any size. So it's not really a small producer tax credit anymore. It's a tax credit available to any wineries up to 620,000 gallons, and then after that you just pay your normal tax rates. But anybody can take these credits, which is great. It saved, I have a figure from Wine Institute, I can't remember off the top of my head, but it saved, I think, almost $2 billion in taxes for the wine industry over the past few years. So this is where we are. There are a couple tricky things with this that don't look like they're being fixed in what's going to be changed in what's coming up in 2020. You can only take the credits on wines you've produced yourself. So if you're a winery and you're producing everything, great, you can take the credits on everything. If you're a winery but make all your reds and have your whites produced for you by somebody else, you cannot take the credits on those whites. That is different than how it used to be under the small producers tax credit. And that's very difficult. That is not being fixed so far, mostly because the industry's view is we just want to get it passed and made permanent, and we'll deal with it later. But that's where we are with that. So custom crush wines aren't eligible, and then bottled or blended wines, part of it is eligible, part of it's not. So you have to kind of do the math there. If you're blending something you produced with something you didn't, you have to look at the numbers in the bottle and then take the credit only on the percent that you blended. Transfers of the credits are not permitted. This is a huge issue for a lot of my clients. I don't know if it's a huge issue for people here, but you used to be able to produce at your winery and then transfer it to your warehouse in bond and have them store it and not pay tax on it until they took it out of bond to ship it out to your customers. That's not possible anymore. Bonded wine sellers can no longer pay excise tax. They can pay them, but they can't take the credit on your behalf. So if you ship wine to a bonded wine seller to store for you, they can pay the tax for you, but they have to pay the full $1.07. If you only want to pay the 7-cent rate, you have to tax pay the wine when it leaves your winery premises, and then it goes into storage tax paid. There's one workaround for this called the alternate procedure that they came up with. This is a perfect example of Congress and TTB not really knowing how things work in the wine industry. So they came up with this alternate procedure after the fact when we explained to them, like, this doesn't work for anybody. Everybody's wines are in warehouses already. And so the alternate procedure basically says that if your wines are already at a bonded wine cellar, you can either transfer them back to your own warehouse and pay the tax and then transfer them again, or do that transfer on paper. So now most bonded wine warehouses have come up with form paperwork to do this alternate procedure that basically says they've transferred it to them, they're paying the tax, and now they're transferring it back to us for storage tax paid. And that's how people are dealing with that. And I suspect that's how it will continue to be dealt with until they are able to get these transfer provisions in. So the status of that, as I said, is pending. Today, December 5th, is called the Day of Action with Congress. The Wine Institute is encouraging everybody to contact their congresspeople. Our California congresspeople are full support of this, but it's always good to have numbers. They're encouraging everyone to contact their congresspeople to say you support the Craft Beverage Modernization Act, which is what it's currently called. And we're hopeful that it'll get passed, but it's in 3 weeks. So hopefully it'll go in. If not, we revert back to all the old tax rates, all the old credits, small producer tax credit. I don't think that's going to happen, but different world right now. So, okay. Any questions on the excise tax rates before I move on? It's very exciting. Okay. Proposed federal labeling changes. So, as everybody I'm sure knows, our federal regulatory system requires that all labels for wine, beer, and spirits conform to certain requirements, and that any label that will be sold into commerce either get a federal label approval, a certificate of label approval, which is called a COLA, or get an exemption. So if you're only selling in California, or you're only going to export it, you don't have to satisfy all the same requirements. That might change, but you still have to get an exemption, at least. You can't just do nothing. So TTB knows that their rules are overly complicated and overly burdensome on not just industry, but also TTB. And also some of them are quite confusing. You know, these rules, again, were written a long time ago and haven't really seen any development since they were originally drafted. So they proposed a pretty extensive labeling revision, tasked with one person at TTB who luckily is he's a lawyer and he's very smart. So it was in good hands with him. But when the regulations came out, we saw a lot of things in there, again, that really didn't reflect how the industry works, or how labeling works, or how, you know, certain terms of art are used. So this is a huge document, hundreds and hundreds of pages, so we're not going to go through them, but what I will go through is some of the hot topics that were really focused on by the different trade groups, like the wine, the Napa Valley Vintners, and the other wine industry groups. So the first one was the issue of, and these are not in necessarily order of importance, they're in order of how they come up in the code, because that's how I kind of went through the code to kind of go through these issues for you. So the first is the issue of estate grown versus estate bottled. Currently, the term estate grown is not dealt with in the federal regulations. It only deals with estate bottled. For you to be able to make an estate bottled claim on your wine, it needs to be grown on property that you own or have full control of via a lease for over 3 years. And you have to, there's several rules, but the two basic ones are then it also has to be produced by you at a winery in the same appellation as where you grew it. So if I own my vineyard in Calistoga, I can only put estate grown on it if I make it at a winery also in Calistoga that I am licensed as a winery at. I can't have it custom crushed for me, I have to make it. Those same rules apply to the term estate grown, which doesn't really make sense because it has nothing to do with bottling, right? The idea of grown is just where were the grapes raised. But currently that's how it is. So TTB has proposed a different definition. Their definition was basically the same as the old definition. So the industry, spoke up during the comment period and said, well, really don't need this bottling requirement in here for estate grown. It really should just be about the fact that you own or control the vineyard that the grapes are coming from. All these changes are still pending. These are all just comments that were made. I have no idea, and I have not heard anything recently on what their proposed timing is for coming out with a new draft, but these are all pending. They've made a lot of changes or suggested changes on health-related statements. TTB currently prohibits any sort of health-related statements or claims on your label, or anything that has curative value. So for example, I had a client who was a pharmacist by trade, and his label was a picture of like a pharmacist holding a medicine bag. And the name was just a family name. It had nothing to do with medicine, or there was no claims on the label that said it had curative properties. It took a long time for us to convince TTB to let that label through. And it took work. So those are the kinds of things that they're gonna be more flexible on, and trying to adding language that they're gonna look at things in context. Definitions of appellation of origin and use of the terms. This is related to another one that's on the next page. They're gonna start allowing use of grape origin terms. So you can say, in addition to appellation of origin, you'll also be able to say where the grapes originated from, Napa Valley, Sonoma, Alexander Valley, whatever, but they haven't really done it in a way they've done it in a way that's likely gonna cause a lot of consumer confusion when you have all these different statements. So we're seeing a lot of comments about that, number one, the grape issue is where the grapes are grown, and that's what that should be focused on. AVAs and appellations of origins are about not just where the grapes are grown, but it's called a designation of place. That's kind of how they term it. It's more than just where they're grown. It's kind of a whole area, and that's how AVAs are. It's the whole area. It's not just the grapes, because there's a lot of other factors that go into it, such as climate and soil. So we're seeing a lot of comments there to make sure that not really opposing these statements, but requesting clarification as to, for example, if you're going to put a statement of grape origin, it needs to be listed in conjunction with the AVA, so it's clear that, this is the AVA, but this is where the grapes are grown, so there's not confusion. Packaging issues, that's very vague. They're working on dealing with essentially what kind of language needs to be on your packaging when you have, now we're seeing a lot more smaller bottles and aggregate packaging, and the regs aren't really clear on what's supposed to be on those packages. The container labeling requirements they have currently really deal with like your case package. It's not really the consumer package. So as is, it's currently what has to be on your bottle has to be on the container. So they're thinking through that. They're looking at giving the industry more flexibility as to where the required terms are. Currently, there's a couple things that are mandatory information. It's only right now the brand name and class type. There's not very many things left in mandatory information anymore. And those have to be on your brand label, which for wine can be either your front or back label. But they're, I think, going to change it to say, as long as the mandatory information is somewhere, it's okay. Trade groups are requesting, though, that they at least be together. So we'll see what happens. This is a very interesting one, and we're going to talk about this more later, uses of the term light and natural. So obviously there's been a huge push in natural wines in the past few years and a huge push in kind of health-conscious, fit-friendly wines. And we see the terms thrown around a lot, light and natural. Light we're going to talk about in my next kind of segment. So let's talk about natural. There's no real term in TTB for natural wine other than that it doesn't have brandy added to it. But the common understanding that's being used now of natural wine is quite different than that. It really focuses more on kind of like an organic or biodynamic idea, and that's not what's reflected. So TTB actually just requested comments on those issues to get a better understanding of what the industry's perception is of that term and light. Light, as TTB defines it, relates to the percentage of alcohol, not calories or carbs or anything like that. So we'll see what happens there. The last two I'll just touch on is statements of aging. They wanted to add a requirement that everybody list on their label how long something has been aged in barrel on every label. And so everyone opposed that. It's overly complicated, especially if you have blends. Could you imagine? So hopefully that'll go away. And then lastly, it's multi-county and multi-state labeling. They already have rules on this, but they're quite confusing and they often conflict with state rules. So I think they're working with the trade groups to just determine what's the best way to list it in a logical way that won't be confusing and easy to implement by the trade. Grape source information we already talked about. And grape source information is one thing. This is where my grapes originated from. Grape varietal listing is another. TTB, I have no idea why they did this, proposed that you have to list the percentage of every grape varietal listed, included in your bottle on your label. So again, of course, the trade groups opposed this and said, it should basically stay the same. If it's over 85%, then you can call it Cabernet, right? But if it's less, then you should list, or if it's more, you should list what the other percentages are. So we'll see. The couple other things, misleading origin statements and obscene advertising, these were just very broad general statements that TTB made and hard to pin down what they're going to do with it, so we're waiting to see. And the misleading origin statement is one that is interesting. We see a lot of people have their labels denied because their back label, for instance, talks about where they grew up or where they own other vineyards, or where, if you have a big winery that owns 12 vineyards and they just want to have one back label that talks about their holdings, TTB has been throwing out these labels and rejecting them because they're saying you're making an appellation claim, which you're clearly not, because the appellation's already listed where required. It's just, and so we've asked TTB to include some information and some guidance as how these will be interpreted and taken maybe in the right context, it doesn't cause consumer confusion. No one's going to think if you list 7 appellations or vineyards that, you know, you're saying all this wine came from all of them when it clearly says Napa Valley or Sonoma on the top. All right. Any questions about labeling in that? Yes.
How would the appellation of origin be different from the ADA or the vineyard? Can you repeat the vineyard not being that ADA? Can you repeat that? Just so we have it.
Oh, yeah, sure. I was just asking how the appellation of origin is different
So you
than
can
the
only
vineyard
use
designation?
appellation of origin if you qualify for certain requirements, like you have to produce it. It depends what the appellation is, but let's say you want to use Napa as your appellation of origin. You can only use it if you produce and finish the wine in Napa. But if you buy grapes in Napa, but you take them to Oregon to finish them, you can't say it's a Napa Valley wine. So what they're proposing is being able to say that the grapes were from Napa Valley. We see we see this a lot. The reason this came up is that mostly because of the Napa Valley vintners, you're seeing a lot of wines called Napa Valley wines that are being produced in like Texas because they're using Napa grapes, and that's not permitted. You have to finish it in essentially in Napa. There's a lot of rules, but that's basically, it could be finished somewhere else in California also, but you know, the vintners would like to see it just in Napa. So that's what they're going towards.
Is there any action on the term old vine?
It's probably in there, but yeah, none of those terms are, you know, reserve, old vine, select. I don't remember, these came out about 2 years ago, the proposals. So I don't remember if that one specifically is in there. They did address a lot of those kinds of terms, select, reserve, and they were more requesting industry comment on what those terms are and if they wanted to see them regulated. I don't think there was any proposed regulation yet on those terms. Another big area of labeling that was dealt with in a completely different notice of rulemaking, which I don't really know why, was standards of fill. Currently, wine has to fall into about 10 different standards of fill to be valid. 750, 1L, Magnum. You can't have random sizes. You cannot have 250 mLs. But because of so many changes, and especially because of the evolution of canned wine, which are all in 250 mLs, the industry has been talking for a while with TTB about adding new standards of fill. TTB's response was to propose a complete elimination of standard of fill. On first blush, you think, oh, that's great, less regulation. But really, it's a horrible idea because every state is then going to have their own regulations for standard of fill, because currently most of them, few of them don't, but most of them just say we defer to the feds on standard of fill, so as long as you satisfy one of theirs, we're okay. So all the industry groups have opposed this. They have proposed adding specifically the 250 ml as a standard of fill. Currently, the only way you can sell 250s is in a 4-pack or other configuration that equals a valid standard of fill, but a lot of people aren't doing it. They're not complying. A lot of retailers don't know these rules, so they're just taking them out and selling them individually, even though they say not for individual sale. So just really from a practical point of view, I'm sure that's going to be added. The question is if they're just going to eliminate it. I don't think they will. So.
Currently on the 250, do you have to put that on the label, not available for individual sale, or is that not a part of the label?
Yes. So the question is, do you have to write not for individual sale on a 250 ml? Yes. So it has to be in a 4-pack that's like sealed somehow. Again, you see those open 4-packs all the time. And then it has to say on each 250 that it's not for individual sale. So because the acceptable standard of fill is usually the 750. So they're putting a few of them together, or 1 liter. So they're putting 4 of them together. 375 is an acceptable standard fill. That's a half bottle. And 187 is also, so you're seeing a lot of 187s out there. Yep. Anybody else? Okay. 15 minutes. Ooh, geez. Okay, we're gonna fly through this. So, nutrition statement. So as I talked about, we're seeing a lot of activity in the nutritional world. People saying that wines are low calorie, low carb, healthy, and TTB actually dealt with this way back in 2004, and then again recently dealt with it in 2013. The biggest takeaway from all of this is if you're gonna make any sort of claim that something has low calories, you cannot say the word low calories, by the way, but if you're gonna say something is light, or if you're gonna make a caloric or carbohydrate claim or sugar claim, you have to have a serving facts statement or a statement of average analysis, which is this. So you're not used to seeing this on wine and alcohol, right? You're used to seeing this on food, and food is governed by the FDA. But because of these claims and to prevent consumer confusion, TTB has now said, okay, well, if you're gonna make these claims, you have to substantiate them. So the most recent guidance calls for serving facts. The 2004 guidance called for statement of average analysis. They're very similar. The difference essentially is that what's the way in which you're stating it. And the main difference is that the serving facts statement includes in it the serving size, whereas the statement of average analysis, you could just kind of put it anywhere. So for that reason, really, if you're gonna make these claims, you have to have a serving facts statement. That's kind of based on their most recent guidance. This is not the law. This is just TTB's guidance currently. It's probably gonna come into the regulations at some point, but none of this that we're gonna talk about was actually in their proposed regulations. So we'll see. I'm just gonna do a quick run through of these topics. Low calorie. You definitely cannot say low calorie on your wine. If you want to list your wine, then if you want to list your calories, 5 calories per serving, you can do so, but you have to have that serving facts statement on there. If you want to do a calorie comparison, you can only do it to someone that also has a serving facts statement on their bottle. So that's hard to do because a lot of people don't have that in this business. And if you want to do it to your own wine, you can do it. But you have to have the statement of average analysis on your light wine. So if you make a regular calorie and a low calorie wine, you can do that to your own wine, but as long as you have the serving facts on your own wine. It's very detailed. So if you're gonna do these kind of things, definitely talk to counsel because it's kind of complicated, especially because it's not in the regs. So this is all just developed through working with TTB and coming up with what their guidance is. You can never say, and you see this, you can't compare. Rules are different for spirits and beer, by the way. So I know some of you might be thinking about beer, it's different. This is wine. So you cannot compare your wines like the average white wine, the average Cabernet, that's not allowed. Light claims. So as I mentioned before, TTB views light as any wine that is between 7 to 14% alcohol. They don't view the term light as having anything to do with calories or carbs. So if you're talking about calories or carbs, you need to comply with the calorie and carbs statement. Light can be in a brand name if you're talking about calories or carbs, but again, you have to have that serving facts statement. And we're just kind of waiting to see what they're going to do with it. Low alcohol, TTB does not have a definition for low alcohol. Again, 7 to 14 is what they call light. The excise tax regulations call a low calorie wine something that's below 8.5. So one of my clients took that route, saying it was lower alcohol. Again, this is untested and we're waiting to see what's gonna happen. Sugar claims. A lot of people like saying things are low sugar. You can see how detailed and complicated this is, right? But basically, if you're gonna say something is 0 sugar, no sugar, sugar-free, it has to be less than 0.5 grams of sugar. And again, you need that serving facts statement. We see similar things happening now with sulfites and low sulfite claims, and those are very hard to make unless you're basically at 0. So, and almost no wines are at 0. So, and that's it. So we're waiting to see, the most recent ruling was from 2013, so 6 years old, almost 7 years old now. They was not in the proposed regulations, which was surprising to a lot of people because this is a big area for us that we deal with. We're seeing a lot of industry, especially in beer and spirits, voluntarily do this, especially on their websites, not necessarily on their labels, but in their advertising, they're starting to share this information. And we're seeing a lot of things in the EU on this. It looks like they're going to start making it mandatory, but it might not have to be on your label. It might have to just be, maybe through a link that people can get to and go look at it on your website. So we'll see. Questions? Okay, direct shipping. So this is what the United States looked like in 2004 for direct shipping. Blue is where you are allowed to ship to as a winery. This is super quick history just to give you some context for where I'm going. 2005, Supreme Court decided the Granholm case that basically said a state cannot discriminate versus in-state and out-of-state interests. That's Commerce Clause, right? So if California is going to allow an in-state winery to ship to California consumers, then it has to let out-of-state wineries ship to California consumers. So the Wine Institute spent the past 20 years changing our map to look like this. That Supreme Court decision didn't mean everyone had to automatically allow shipping. It meant you decide what you're going to do, but if you're going to allow it, you have to let everybody do it. And by the way, you also have to draft regulations to make that happen. So now we're doing pretty good as wineries go. And so the next big thing is really going to be retailer shipping. We've been dealing with retailer shipping for a long time and issues with it. You can see the map is pretty limited where you're allowed to ship. A retailer is a restaurant, a bar, a wine shop, Safeway, anyone that sells wine to consumers directly. Wineries are not retailers, they're suppliers with retail privileges, so it's different, right? So this is where we are with retailers. Just this year, the Supreme Court decided the Tennessee Wine and Spirits Retailers case, which, thank goodness they did it, because this has been happening in our business for about 20 years. The wholesalers have been pushing the argument that the Granholm case only applied to wineries. It only applied to wineries, so the analysis there that you cannot discriminate between in-state and out-of-state commerce did not apply. That is not how the law works. The law applies regardless of facts unless the court specifically says so. They did not say that in Granholm, so the Supreme Court basically said, obviously it applies. But we've been waiting for them to do this for a very long time. And very interestingly, this case had nothing to do with direct shipping. This case had to do with Total Wine wanting to hold a license and open a Total Wine in Tennessee. But Tennessee has a law that says to be a retailer in Tennessee, you have to have lived here for 2 years. And then on top of that, you also have to have lived here for 10 years on a separate level. So clearly was discriminating in favor of in-state interests. And so in the only case dealing with that in the context of alcohol was Granholm. And so for the Supreme Court to be able to decide this case regarding residency requirements, they would have to decide whether Granholm applied in the retail sphere and was not just limited to wineries. So in doing so, they basically shot down all the arguments that have been used in all the direct shipping cases for many years by the wholesalers to say it's not permitted. So now, where does that leave us? That leaves us as the states having to decide whether they're going to allow direct shipping by everybody or direct shipping by nobody for retailers. Consumers obviously would like to see, especially in California, we have so much wine and we're very open and we get everything from all over the world. A lot of states in this country, they have like 3 shops that supply all the wine and they're really restricted. So, in those states, they'd really like to see it open up. Wholesalers would not like to see it open up at all because that is 100% cutting into their 3-tier distribution system, even more so than the wineries did. So we'll see. And how does that affect you as wineries? We'll see. Maybe it's good. Maybe it gets your wine into more states and more distribution, or maybe it takes away from your own direct-to-consumer shipping because someone can now buy 7 different wines from one retailer instead of having to go to 7 different winery websites. This is all, really new and, I don't think, it's easier to make the changes than it was for wineries because the regulations are already there. It's almost like a plug-and-play situation if the state decides it does want to allow it. But it's just going to be the battle of getting to that decision point of do we want to allow this or not. Okay, questions on shipping? Okay, I have 2 more. I'm going to do them super quick. And the last one especially because it's not my area of expertise. Responsible beverage service. In 2017, the California legislature passed a statute requiring essentially responsible beverage service training for anybody serving alcohol in the state of California by 2021. That's your tasting room people, the way that ABC has defined it, that is people checking IDs, that is waitresses. It's basically anybody serving or monitoring or managing the consumption of alcohol. TTB was tasked with enacting regulations to put this in place by January 1, 2020. They came out with regulations in October. They were extremely burdensome. They have created this huge scope, a number of people that have to get licensed and qualified with RBS training. And they've put a lot of kind of an onerous burden on the licensees and their staff. So they also gave a very short comment period to let anybody respond. So they got a lot of pushback and they extended it. And so they've recently closed their comment period. Comments they got were basically you're exceeding, the purpose of the act is so people can prevent overconsumption and prevent drunk driving, right? That's the reason for this. And requiring someone to take a test that knows that they understand the physiology of how alcohol flows through the human body is probably beyond the scope of what is required. But that is currently what ABC is requiring. This is a huge issue, but the laws will be in effect by January 1st, 2020. And as a winery or anyone serving wine, you're going to be responsible for making sure that your employees will take this test by 2021 before they start working for you. And there will be, ABC is not the one who gives the courses. There will be a list essentially of qualified agencies that can do RBS training, but the test is administered by ABC and you have to have a 70% to pass. So there's questions there also of discrimination against English as a second language speaker. Are they going to have it in Spanish? These are all the things we're waiting to see in their revised regs. That's very new. This just happened in the past month or so, so we're waiting. Drea?
I probably don't need the mic. Do you foresee that there will be any industry groups or law firms that will continue to fight it, or is it like done deal?
People are still fighting it because they didn't, in the last round of revisions, make very many revisions in response to like the deluge of comments they got. I mean, this is not surprising. If anybody here knows the general counsel of ABC, he's like pig-headed. And so, they had it in their head, this is how they wanted to do it. So this is what it is. And so, but I know, like Hinman is heavily working on it because he represents a lot of retailers. And they're the most impacted by this, absolutely. So we'll see. So keep your eyes out. They haven't really been doing anything. They didn't even put out a press release. They barely put out a press release saying the comment period was open. This last topic is super fast because it's not specific to alcohol, but you should be aware of it. California passed in 2018 the California Consumer Privacy Act. It basically requires anyone that is subject to it, which I'll get to in a second, to redo the way their website operates in terms of taking in consumer information and the disclosures that are required and letting them opt out. This is definitely out of the scope of my area of practice, but it impacts a lot of our clients, and a lot of our clients are just voluntary complying even though it doesn't. It only applies to certain businesses, those who have gross annual revenues in excess of 25 million, those that actually sell personal information, or those that derive 50% or more from selling personal information. So it's not a huge, it doesn't encompass like everybody in the wine business, as I was saying, but it does impact a lot of people. And because of that, a lot of people are just voluntary complying to be, give these privacy protections to their consumers. One thing to note is that it does impose different obligations than the EU's GDPR, which is the General Data Protection Regulation. That was the EU's kind of regulatory privacy scheme that they came up with that says applies to anybody in the world that has customers from the EU. There's jurisdictional issues there. How is the EU going to enforce something over a California winery? It can't really. But those are different. So if you have a lot of EU customers, you have to also think about complying with that. If these are issues you think are important to you, you should definitely talk to probably intellectual property counsel. and they can help you work through those issues. Okay, we have like 10 seconds. Does anybody have any final questions on anything I talked about? All right, hopefully that was helpful and you guys got a sneak peek into what's coming. Thank you.